My name is Jay Chauhan. I am a deputy judge in Richmond Hill for 21 years. I'm also a lawyer practicing in this town, Richmond Hill, for the last 40 years. And today's subject is the question of pleadings in the small claims court. And for that discussion, I have Mr. Ahmer Hussain, who will frame the questions and address the questions about the issue of how to draft the pleadings and what are the key elements of the pleadings in the small claims court of Ontario.
Right, exactly. Okay, so I guess to start off, my first question would be, what is the best way to present pleadings in the small claims court?
The best way, in my view, Ahmer, is that you present that with identifying the cause of action, which is the legal categories in the law which you have to bring it to court. Everything that you're upset about is not capable of being addressed in the legal system. Therefore, when you bring it to the legal system, you should identify what is the cause of action, in other words, the legal reason, breach of contract, tort, whatever, or statutory duty, and that should be identified in a claim, in the pleadings as you commence the claim.
Okay. I believe on the pleadings form there's a section that asks particularly when, how, and where the action actually occurred, or the event that has brought upon this cause of action occurred. How does one go about filling that part?
Well, I think the form is drafted a little bit casually in my view, and I think it is designed for the average public because the intention of the small claims court is to allow the average member of the public to come to court. And they will not be familiar with the rules and the technical guidelines which I think lawyers and paralegals are aware of. So if the form says where, when, how, it is important to recognize that if you're a paralegal or a lawyer, then I don't think that you should just go by that form, but rather present it the way you would in a higher court, superior court, where you identify the plaintiff claims, whatever, and then go through the pleading, if you like, in a careful manner to narrate just enough facts, but facts that support a particular reason for the action. That's how it should be drafted.
Okay, I understand that. Are there any resources that one may use to maybe use it as an example to present their pleadings?
Well, the resources, I think, in terms of the CanLii, CanLii.ca, presents very good resources to identify a cause of action, a case law, and a lot of material there. I think textbooks are good also, and I think that it is very helpful each time that you commence an action to really think it out carefully before you draft it. So the resources are there, and today there are many, many resources in the internet which can be used without going to the library. But I still recommend that, especially for paralegals actually, who don't have the same depth of the knowledge of the legal theory, that they make a point of learning those issues as they draft each claim. And that's rather important to look at the resources available to formulate proper pleadings.
Okay, perfect. And when presenting one's pleadings, what kind of documents should one attach, and how many documents should we attach?
Unlike the superior court, in a small claims court, it's very helpful to attach sufficient amount of documentation to justify your claim. And for example, if you have done a contract and the dispute arises from a construction contract, and the contract says, I'll build your basement, and there is a written agreement of the cost, and if you have one, then that kind of a document is extremely helpful, along with other documentation that are critical for the other side and the court to understand what is the nature of the claim.
Okay, perfect. Now, how long should the pleadings actually be?
Well, I would not recommend very lengthy pleadings, because I think the skill of the lawyer or the paralegal lies in trying to present the whole complex set of facts into understandable, identifiable action and the reason for it, and brought into 2 or 3 pages, and that should be sufficient unless the whole situation is very complex. So the sorting out of the facts in a form which is presented properly is the job of the lawyer or the paralegal. So it should not be lengthy. Another reason is that as you probably know, that the deputy judges are basically part-time lawyers who come there occasionally, and therefore they have a number of issues to be addressed, and they will not be able to read the lengthy pleadings if you make it very long. So when you're trying to write lengthy pleadings, then you have to take the risk that the judge will not have the time to go through it in detail, and when you present your case in not in a concise fashion, then some of your important issues will not be looked at thoroughly as you would like them to be looked at. So it should not be too long.
Okay, so everyone's working on a time constraint.
Yes.
Okay. Now, I guess going on that, would it be better if the pleadings were typewritten?
Oh, very much so. You see, when you handwrite pleadings, what it shows is that you're not serious about it. It's not exactly readable because the handwriting, especially my type of handwriting, you're definitely reading. So if you present it that fashion, then I think you will not get the attention that you want from the court in particular. And I think you also want properly drafted typewritten statement to the opposing side, because you want your story or facts to be properly understood even by the opposition. So I think that is very, very important to do it properly.
Okay.
In a typewritten format.
All right, perfect. And how important is sequencing in narrating the facts?
I think sometimes the facts do get complicated because you're trying to sort out the facts and give it a legal analysis. So at that time, the narration of the facts should be the sequential order in which the events happen. It is very helpful to present that sequence wherever it is possible. Then it makes the story more understandable by the opposing side and, more importantly, the court. And therefore it should be roughly in the format of the event. Sometimes I've seen a chronology even presented when the facts are complicated, and I think it's not a bad idea if you have to do it and create a chronology as well, when there's a lengthy facts and a lengthy sequence to be presented.
Okay. Now, let's say if during the pleadings one were to omit certain information, is there some sort of recourse that one may use to amend the pleadings?
Yes, the pleadings can be amended, but I think that it is very important in my view that you give it a full thought to present it correctly from the day one. If new facts arise, which you did not know at the time of the first pleading, then you have to be able to try to figure out how the amendment will help your position. And then you ask for an amendment, it's called a motion. You can go before the judge and ask for the amendment at that time, and then you can continue the trial with the amendment. But it usually an expensive exercise, and it delays the process. So my suggestion is that one should present it properly from the beginning, but it can be amended.
Okay, perfect. And excuse me, my last question would be, in certain cases, actions are brought up against a corporation. What kind of details and how important are all the details of the corporation while presenting a pleading?
What I saw more recent years is that because the corporations shelter the defendant from the parties from the liability, they very often bring the individual into the action and use the card or the letterhead as a means of writing the name of the defendant. And I think it is very, very important that the proper legal entities is researched in the ministry downtown at University Avenue be identified properly, and then his name should be inserted correctly after the research has been done on the name. And where there's a corporation, a full proper name, where there's an individual, his proper name, and not the name he is using as a nickname. This is very fundamental.
Understood. So like if it's a corporation, make sure that it incorporates the LLC or the other designations that the person or the business might have.
Correct.
Okay, perfect.
Good.
So that's it for today.
Thank you, Omar. I hope that it was useful, and thank you very much.